Good morning, everyone. Good morning. We start our class today with the thematic issues, the mains part, layer 2 of theme number 3, right? So let's start. We're going to now be studying layer 2, which is largely analytical in nature and is therefore important for the means part of theme number 3, which is fundamental rights, directive principles of state policy, and fundamental duties. Now, in this, the first thing that we are going to study is the last word of the very first line of the main syllabus for polity, which refers to basic structure. Okay? So what we are going to be studying today, under the larger garb, under the larger understanding of basic structure. तो ध्यान से देखिएगा, ये बहुत important है, थोड़ा सा complicated हो सकता है, but we will keep it as simple as possible and as relevant to the exam as possible. So we will understand the doctrine of basic structure, and under the garb of the doctrine of basic structure, we are going to also understand the doctrine of harmonious construction. Okay? And both of these doctrines relate to two very simple and two very important discussions with respect to the Constitution of India. So, when we study the doctrine of basic structure, when we understand and when we study the doctrine of basic structure, what we are going to basically study, what is our origin going to be, is the amenability of fundamental rights. We will be answering a simple question, which is, can fundamental rights be changed? There are going to be two answers to this, either yes or no. If no, why? And if yes, to what extent? To what extent? And by who? Once we understand this, we will then take the discussion to the Constitution, because fundamental rights are ultimately a part of the Constitution of India. So, can other provisions of the Constitution be changed? If yes, and then no. If no, why? And if yes, to what extent and by who? Okay, to what extent and by who? All right. And as far as the doctrine of harmonious construction is concerned, the origin of this discussion is going to be if there is a conflict between a fundamental right and a directive principle, what will prevail? And once we understand this, we can then apply the same to other provisions of the Constitution. Other provisions of the Constitution. At the outset, I must also inform you that these doctrines are in fact an accidental discovery. When the courts were examining cases which ultimately led to the evolution of both of these doctrines, the courts had absolutely no idea what they were dealing with. And very simple civil issues faced by the people of this country, and these issues, when reached the Supreme Court, ultimately forced the Supreme Court to arrive at these doctrines. Now, at the outset, I must also tell you that doctrine simply means a principle. The Supreme Court has no power to change the Constitution. It cannot add or subtract anything to the Constitution. It can declare the interpretation of a provision. It can declare the interpretation of the provision to be a certain number of things. It can invalidate a provision of any law, including the Constitution. It can declare something is unconstitutional. But the Supreme Court cannot add or subtract anything in black and white to the text of the Constitution of India, because the only people who have the power to do so happen to be the Parliament of India. And we'll come to that eventually. But doctrines simply mean principles, principles which have been evolved, and these principles are used as Supreme Court directions. One can always say that the very fact that you can apply doctrines, the Supreme Court can come up with something called the basic structure, can apply this to the Constitution of India, can apply this as an interpretation to the Constitution of India, is nothing but an act of judicial review and judicial activism, depending from what your perspective is. There is no right or wrong answer to this. One cannot say that this is definitely judicial review or this is definitely judicial activism. But the fact that you can look at an interpretation and how deeply can you interpret something is a matter of your perspective, is a matter of what your individual viewpoint of this particular issue is. All right. Now, while this can sound very complicated, let us understand how we are exactly going about this. We will first understand certain key provisions that are going to be involved in this conflict. Then we will draw a broad timeline. We will then understand, once we've drawn a broad timeline, we will then understand as clearly as we can, we will then understand the key developments according to the timeline, and then we will have the analysis. The most important part as far as your mains exam is concerned is the analysis. The mains exam is not particularly concerned with the constitutional history of the doctrine of basic structure. No doubt you have to understand the development You must understand the chain of events so that you can accurately analyze. I understand that. But that does not mean that your focus is on point 2 and 3 and not point 4. No doubt, questions are asked from here almost on an alternate year basis. Invariably, there are always questions from here. But all of those questions are the analysis of basic structure, are the interpretation of basic structure, and nothing else. So let's understand this, keeping our mains exam in sight. So let us start. First, let's understand certain key provisions. When we look at key provisions, the first key provision that we are worried about, that we are going to be using extensively, is Article 13, Clause 2. Article 13, Clause 2. Article 13 basically, Clause 2 basically says, no law can be made, no law can be made that violates fundamental rights. Okay? You cannot make a law, nobody can make any law that violates fundamental rights. Through the course of our discussion, we will see that the government and the people are going to fight over the interpretation of the word law. What is the meaning of law as far as Article 13, Clause 2 is concerned? What is the meaning of law as far as Article 13, Clause 2 is concerned? Then the second provision that we are going to be excessively getting involved with is Article 368. This is something that we have referred to in the first few classes when we were understanding the applications of majorities to lawmaking. And Article 368 gives you the process by the Parliament to amend the Constitution. To amend the Constitution. Okay? These are the two fundamental foundational principles, fundamental foundational articles that are going to be applied. Okay? And you can see that there is an inherent contradiction in both of these articles. While Article 13, Clause 2 says, no law can violate a fundamental right, and Article 368 says, the Parliament can amend the Constitution. And what if the Parliament amends the Constitution under 368? We know that amendment is going to be called a constitutional amendment. Can that constitutional amendment therefore amend, alter, or change a fundamental right with respect to Article 13, Clause 2? Because 13, Clause 2 says no law can be made that violates a fundamental right. So if the Parliament makes a constitutional amendment to delete a fundamental right, is that going to be valid or not is the question we're going to fundamentally get into. So these are the two foundational articles that are going to be at conflict. They're going to be at loggerheads with each other in the course of our discussion today. Apart from this, of course, we are going to be looking at Articles 14, 19 and 31. Now, our story and our journey starts from the time of the enforcement of the Constitution. So, one of the freedoms under Article 19, Clause 1 and the initial provisions of Article 31, both of them in the earlier times gave property as a fundamental right. Both of these provisions have now been removed, and property today is a constitutional cum legal right under Article 300A. Okay? There are going to be certain changes that are going to be made to Article 31, and therefore they will impact our understanding of Article 13, Clause 2 and Article 368. Now, it is clearly mentioned in the Constitution and otherwise as well as a matter of general practice. If a law is violating a fundamental right, the only people who can get to decide that are, of course, the courts, whether it is the Supreme Court or the High Court. If we are talking about the Supreme Court, you will require a minimum of 5 Supreme Court judges who will have to sit together and decide whether any law is violating a specific provision of the Constitution, more specifically a fundamental right. If a 5-bench, this is called a bench, if a 5-bench judgment has been delivered, then the only people who can overrule that judgment will require at least 7, then 9, then 11, then 13, and then 15. You will require a larger bench to overrule a previous Supreme Court judgment of a 5-bench. These are your basic concepts, certain key provisions that we are going to be looking at some point of time. Interestingly, when we are having a foundational discussion on can rights be changed or not, Article 21 has not played a significant role in deciding the extent to which fundamental rights can or cannot be changed. The 3 principal rights have been Articles 14, 19 and 31, which is equality, expression and the right to property. I hope we are clear with this so far. Now that we are clear with this, let's understand how both of these doctrines are going to function. See, both of these are like the plot lines of a movie. Nowadays, you will often see movies with 2 or 3 plots, with 2 or 3 parallel stories, and these stories come together at a common point. They merge at a common point, and that is when the movie becomes very interesting and leads to a climax of both of these 2 stories. So the primary plot is going to be the doctrine of basic structure. The second plot is going to lead to the harmonious construction. Both of them are going to merge at a specific point of time, and history will be created. Okay? Now, so the first thing we must do is that we must draw a very clear timeline of the matter, and we'll keep coming back to that timeline as and when it's needed. Okay, so we're going to just draw a broad timeline and we'll keep adding things up as and when needed to that timeline. All right, okay, so the story starts from one corner, right? I'd recommend that you also draw this accordingly. Okay, we are going to keep coming back to this particular timeline as and when needed. We'll keep adding stuff to this timeline. Now, as I told you, there are going to be two perspectives to this. This is the first story and this is the second story. The first story is about the amenability. The first story is about the amenability of fundamental rights, and the second story is about a conflict between directive principles of state policy and fundamental rights. Okay? All right. Okay. Now, as and when we get along, we'll keep adding things to this timeline. Okay? So, we'll start with the first story. We'll keep coming back to the first story. The first story is the amenability of fundamental rights. Every movie, every story that you see always has a context, always has a background to which things happen to, always has a reason why X happens and Y does not happen. And the context to this, the origin of this, is the notion that you are all familiar with called socialism. And we understand socialism as the intervention by the state, for equitable distribution of resources. Now, let us draw a parallel here. Okay? Let us assume you are an IT engineer working in an IT firm, right? You may not have a cabin, You may not have a proper cubicle. You may not even have human rights. But there's one thing for sure. Each IT engineer is going to have a laptop or a computer each. Everyone who's working in this sector as an IT engineer will compulsorily have a laptop or a computer. Right? Does everybody agree with this? If you're an IT engineer working in an IT firm, you may not have anything else, but you would certainly have a laptop or a computer each. That means the people, the assets, and the occupation are equally distributed, right? The assets that are needed for the occupation are equally distributed amongst its people. Everybody has a basic computer to begin their professional journey with. Does everybody agree with this hypothesis? Does everybody agree with this basic premise so far? Yes or no? Okay. Thank you, Varun. Unfortunately, the exact same hypothesis does not apply to India's most popular profession, which by the way is not engineering but is agriculture. So, if agriculture is your profession, and most people in India are agriculturists, and another word is a farmer, each farmer would require a piece of land to be able to successfully practice agriculture, but each farmer does not have a defined piece of land in our country. Land is excessively unevenly distributed, right? A very few number of people have large chunks of land. Very few number of people have large chunks of land. So what was true of the engineer versus IT firm is not true of farmers, land and agriculture. With the added disadvantage that if there were lesser laptops for engineers, you could simply manufacture more laptops, produce more laptops and give it to the engineers who don't have it. But you cannot produce more land. You cannot produce more land. Instead, what you have to do is redistribute land from the people who have it and give it to people who don't. And that is the context to discussing this. And if the government wants to redistribute land, take land away from people who have a little too much of it and give it to people who don't, this process is nothing but a socialistic application of land ownership. a socialistic tenure of land ownership. Okay? All right. So we understand this. In the context of socialism, in the context of understanding the elements of socialism, we understand what we are referring to is land ownership. So when we became independent, our constitution was brought into force in 1950. The government clearly thought that the policy of redistribution of land was essential. Basically, how would you redistribute land? You would take land from people who excessively own it and transfer it to people who don't. And transfer it to people who don't. This basically means that there is going to be a limit on land ownership where more than an X amount can't be owned by a person. And if you have more than the X amount, the extra land will be taken away by the government. Right? Now, the issue here is that land, as we know it, happens to be a state subject, which means the central government through the parliament cannot make the national land acquisition law, so to speak. The central government cannot make the national land acquisition, so to speak. Right? The only people who can make a law like that are people who are in the state. It's a state subject. But thankfully, we are talking about the early years of our countries, and therefore we are able to understand that while Congress was in power at the center, several state governments also had Congress-ruled majorities. What is true for the BJP today was true of the Congress in the early years of India's glorious history, which basically means history often repeats itself. So therefore, all that the Congress party high command Jawaharlal Nehru had to do was call up the respective chief ministers who were Congress chief ministers in a large number of states, tell them that you need to make a law restricting land ownership and start buying land from people who have an excess amount, give them a fair price, give them a good deal, but buy the extra land from them and redistribute it to people who don't. This land acquisition or land distribution does not mean that, for example, in a state A, you are only allowed to have 10 hectares, and if you have 12 hectares, the government is going to snatch 2 hectares away from you. No, it is going to buy 2 hectares from you compulsorily. It is going to buy 2 hectares from you compulsorily. You don't have an option to not sell. The government is going to give you a fair price. The government is going to buy the additional 2 hectares from you and give it to people who don't have it, right? So upon directions from the central government, several states started enacting land reform laws. Several states started enacting land reform laws or land reform acts, right? Several states, Bombay, Madras, UP, MP, Bihar, etc., etc. Quite a few, all right? Now, this started happening, and this is the context through which the whole story began. Does everybody understand the context? Are we okay with the context? Is it fine so far? Does everybody understand what is happening so far? Yes. This is a state subject in Schedule 7 under the state list. Now that our context is sorted, let us understand the implications of the context. The implications of the context. The context of several land reform laws enacted across different states. Several land reform laws enacted across different states. Okay? Okay. Now, the implication here is on fundamental rights. Why? There are basically 3 fundamental rights, as we had highlighted before, that seem to be violated because of these farm laws. 3 fundamental rights. And we will do this in the order of precedence, not in the order of occurrence. A direct violation of this is Article 31, which categorically gave you the right to property. It categorically gave you the right to property. Then it also had an implication on Article 19, Clause 1. Okay? So, Article 19, Clause 1, Clause F. Now, this does not exist anymore. This particular provision also referred to the right to dispose, acquire property. Simple violations of land reform laws. If I have a fundamental right to property, I have a fundamental right to own property. Now, if I have a fundamental right to own property, then nobody, including the government, because fundamental rights are available against the state, and here it is the state only who is wanting to snatch my fundamental right to property by buying property that I don't want to sell, by compulsorily making me sell property that I don't want to. So my 31 and 19 largely seem to be violated. And not only this, my Article 14 also seems to be in trouble, because what is happening here is that this land law is treating two sets of people differently before the same law. If you are an owner of land and you have an excessive piece of land, then your land, excessive land, is going to be purchased by the government. And if you're not an owner of land, then nothing is going to happen to you. In fact, under the same law, you are going to get land that you never had dreamt of. And on what basis are you deciding these limits? That you can have 10 hectares or 20 hectares or 50 hectares or 100 hectares. Under what basis are you going to decide how much land can you or can you not hold is in fact a matter of great discussion. So that is why 31, 19 and 40 are the three fundamental rights which have been violated in the context of all of this. Right? Now, we all know if your fundamental rights are violated or seem to be violated by a law or by any reason, then under 32 you can go to the Supreme Court, and under 226 you can go to the High Court, and both of these can challenge what are called your laws. So people started going to the high courts. So several cases were filed across several high courts by the respective landowners challenging their respective land reform law of their states. Is this clear, everybody? If you could let me know if this is clear, this is extremely important. That several petitions started going. Okay? Do we understand this? Yes? As a result of this, now this is a story basically. So then, when several petitions were being filed at several high courts across the country, this matter reached the center. The center, under the leadership of Pandit Nehru, was arguably upset, was arguably pissed off that here we are trying to help people, but look at these entitled landowners who are not letting us do the job. So in the very first year of the country's constitution coming into force, within 1 year itself, the very first constitutional amendment was enacted. Now we know that under Article 368, the Parliament can amend the Constitution. So using the powers of Article 368, the Parliament enacted the first constitutional amendment. The first constitutional amendment. This amendment came into being in 1951. So what did this amendment do? Very smart amendment. This amendment basically added two sub-articles and a schedule to the Constitution of India. And these two sub-articles were added to Article 31. And we know whenever new articles are added, they're always added with a capital letter. They're always added with a capital letter. Okay? So, what did we do? We added under Article 31, we added 31A and we added 31B. 31A just set the record straight. It wanted to put an end to this misery. So the government enacted this first constitutional amendment under Article 31A and said, boss, no fundamental right is violated if the government is acquiring property. No fundamental right is violated if the government is acquiring property. बात ही खत्म हो गई कि अगर हम आपकी प्रॉपर्टी खरीद रहे हैं तो फंडामेंटल राइट की कोई बात ही नहीं है. कोई इसमें दिमाग ही मत लगाना. और अगर गलती से लगा भी दो then we will have the provision to protect certain laws. There are certain laws that can be protected from scrutiny by the courts, and therefore under 31B we will create what is called the ninth schedule, and the government added almost all the state land reform laws to the ninth schedule. बेसिकली जवाहरलाल नेहरू सेट मार्केट में जाओ, डब्बा लेके आओ. ये जितने भी लॉज चैलेंज कर रहे हैं ना हमारे जमींदार स्टेटों में, सारे के सारे लॉ को डब्बे में बंद करो, सील करो, स्टिकर लगाओ 9 शेड्यूल, और ऐलान कर दो 31B में कि जो भी 9 शेड्यूल के अंडर है उसमें कोर्ट नहीं जा सकती. इफ अ लॉ इट इज अंडर 9 शेड्यूल एंड इट इज वायलेटिंग फंडामेंटल राइट्स, भाड़ में जाओ. The Supreme Court or the High Court cannot get into it. Any law, even today, if it's under the 9th schedule, it is immune from judicial review. There are now certain terms and conditions to it. We'll come to those later. But this is largely what the 9th schedule is. Okay? This is largely what the 9th schedule is. ठीक है? समझ में आया? यहाँ तक क्लियर है? Okay? Understood? यूपी, बिहार, एमपी, मद्रास, सबके. ठीक है? All right. So, let us plot our developments so far. कि भाई अभी तक हुआ क्या है, क्या चल रहा है. So let's understand क्या क्या हुआ है भाई. There were certain land reforms. These land reforms led to the enactment of the first constitutional amendment of 1951, which added two fundamental rights, 31B and 31B, 31A and 31B, which created the ninth schedule. Right? Okay. Prashant, you're asking me to teach while seeing in the camera. I'm not performing an item song in front of you. I'm discussing a legitimate, constitutionally complex problem of this country. So pay attention to what I am saying than worrying about where I'm looking when I'm saying what I'm saying. Okay? So 31B basically inserted the ninth schedule. Alright. Now that we are clear with this, we understand exactly what is happening. The stage is set. It is absolutely set for the drama to unfold. Right? The stage is set for the drama to unfold. Basically, now zamindars cannot challenge the land reform acts because they are placed in the ninth schedule. Right? But one second, life was never that simple. Life was never that easy. So basically, there were still very, very smart people. In 1951 itself, there was a zamindar by the name Shankriprasad. So Shankriprasad, now of course his lawyer, Shankriprasad, okay, the lawyer had a very interesting thought. Said, okay, I cannot challenge what is inside the ninth schedule, but I can challenge the ninth schedule itself. How did you create a schedule that restricts the courts from looking into the laws inside it, even if they are violating fundamental rights? How dare did you make this happen? I know I can't challenge what is inside the box, but I can challenge the box as a whole. And that's exactly what happened in the Shankriprasad case. In Shankriprasad versus Union of India, which is the center, this is the case of 1951 itself, and it was a 5-bench case. Okay? The lawyers of Shankriprasad argued in the Supreme Court. The lawyers of Shankriprasad argued in the Supreme Court that, you know what, the insertion of Schedule 9 is unconstitutional. The Parliament does not have the right to restrict the application and the review of fundamental rights. It does not have the right to take away a critical analysis of fundamental rights in the country. And you therefore cannot violate somebody's property because property is a fundamental right. The government's lawyer, Attorney General at that time, the government's lawyer argued and said, all of this is nonsense. Article 368 gives me the power as the government to amend anything in the Constitution. Who gave you the power? Who gave the courts the power to review fundamental rights violation? The Constitution did. Who has the power to change the Constitution? I do. I am the Parliament. I have the right to do so. So if I am exercising my rights under 368, who are you to tell me this problem? And let's not forget, Article 13 Clause 2 says no law can violate a fundamental right. No law can violate a fundamental right. I understand that. Okay. No law can violate a fundamental right. I understand that. But excuse me, constitutional amendments are higher than ordinary laws. Constitutional amendments have a higher legal standing. They have a higher moral standing. You cannot equate constitutional amendments to law. Because if constitutional amendments meant law under the meaning of Article 13, then I will never be able to change the Constitution. Because every time I want to make a difference to a fundamental right, change it, adapt it, evolve it, you will suddenly say, you don't have the right to do so. But I have the right to do so. So this is a catch-22 situation. The lawyers of the government argued, "Arey, what nonsense is this? How? If constitutional amendments were to be included under the definition of law, then I will never be able to evolve the Constitution. Because every time I made a change to a fundamental right, you people will come and tell me you cannot make any change to fundamental rights. Then how will I evolve fundamental rights? It's okay, I'm evolving fundamental rights within 1 year, but it is my right to evolve." Now, of course, the Supreme Court completely was swayed by the arguments, of Shankriprasad. All of the 5 judges in the Shankriprasad case very, very clearly said, you know what? The Parliament enjoys the absolute power to amend the Constitution. And in the Shankriprasad case, the Supreme Court said, you know what? There are 2 kinds of powers. One is a constituent law-making power, and the other is an ordinary law-making power. And the constituent law-making power lies with the lies with the Parliament, and this refers to amendments to the Constitution. So the powers of the Parliament to amend the Constitution are Parliament's constituent law-making power, and the power to make any other law is an ordinary law-making power. You cannot equate the two. If the Parliament has the powers to change the Constitution, that should not be included in the larger definition of law as per Article 13 Clause 2. This was the judgment given by the Supreme Court. Okay? And therefore, the constitutional scheme of India gave rise to this kind of a distribution. So obviously, Shankriprasad did not get any relief. The land was not given. Okay. Now, this obviously made the government very, very confident. Made the government extremely confident. And the Supreme Court said very clearly that the Parliament can change any fundamental right. No problem at all. Can change any fundamental right. And also at the same time, constitutional amendments are not law as per Article 13, Clause 2. As per Article 13, Clause 2. Okay? Clear? Bas. all you need is a win to become confident. So whenever you clear the prelims, you will have an air of confidence that I am able to crack it. I am right there, it's only a matter of time. Okay, so the government got extremely confident, extremely, they said the world is on our side, the judiciary is on our side. And then the government enacted the 17th constitutional amendment of 1964, a few years later. The 17th constitutional amendment of 1964. And through this, so the government basically added more laws to the 9th schedule. Added more laws to the 9th schedule. More than 40 different kinds of land reform laws across multiple states and provinces. Some had 2 or 3 land reform laws for each state. And the two states that were added were Rajasthan and Punjab. The 2 states that were added were Rajasthan and Punjab. And this led to the next 2 very important cases. Okay? So from Rajasthan, there was a zamindar called Sajjan Singh. So the next case was Sajjan Singh versus State of Rajasthan. Sajjan Singh versus State of Rajasthan. Again, you needed a minimum 5 bench or higher, so you had 5 benches sit together in the Sajjan Singh case in 1964. Minimum 5 bench. Now here also, the lawyers largely argued the same. They just said that no doubt the parliament has the powers to amend the constitution. No doubt the parliament can do whatever it wants to. But the procedure through which the parliament can amend the constitution, that is problematic. You have to take the account of states. The procedure through which the 9th schedule was passed, that is flawed. Okay, that is flawed. And therefore, as a result of this, the 9th schedule should not exist. But the Supreme Court more or less gave the same kind of judgment, very similar to Shankriprasad. Very similar to Shankriprasad. Almost verbatim to Shankriprasad. They said, ठीक है, procedure ठीक है, अपनी बात अलग है, but देखो, नहीं कर सकते तो नहीं कर सकते. The parliament has the constituent power under 368 to make constitutional amendments. बड़ी सीधी बात है. And those amendments will not be considered law as far as the definition of law under Article 13 Clause 2 is concerned. ठीक है? As far as the definition of law under Article 13 Clause 2 is concerned. You must understand the fundamental conflict. That on one hand you are saying that no law can violate a fundamental right. And on the other hand you are saying the parliament under 368 can make any change to the constitution. If you don't let the parliament to make any change to the constitution through a constitutional amendment, then you will never be able to evolve the constitution. Because every time the parliament made a constitutional amendment, making a change to a right, if it's a positive change, we will all celebrate. But if it is a negative change, we'll say, under 13 clause 2, you can't violate it. Sometimes a fundamental right needs to be violated for the constitution to evolve. That is the argument given by the government, and that is the argument which is largely given by the Attorney General, and that is the argument which is largely also given a certain verdict. And that is why in Sajjan Singh's case, very similarly, the court ruled in favor of the government. This person also did not get the land back. ठीक है, इसकी भी जो लैंड राजस्थान लैंड रिफॉर्म लॉ से जब्त हुई थी वो वापस नहीं मिली. Very, very similar. Government even happier. The government even happier. Okay? Understood this? Correct? Yes? Now, super happy. But from the state of Punjab, the story changes. From the state of Punjab, the story changes. One of the richest zamindars of Punjab, Golaknath, had more than 500 acres of property. But the Punjab state law, the Punjab state agricultural reform law, made sure that a substantial chunk of Golaknath's property had to be compulsorily bought by the government of Punjab. Obviously, Golaknath was furious. 500 acres of property in the golden days meant a lot of property. Generations after generations would Golaknath never have to work at all. Right? So he challenged the land reform laws of the Punjab government. And that is how the first difficult case came. Okay? The first difficult case came. And this is called Golaknath or IC Golaknath. You can write Golaknath, that is more than enough. Versus the state of Punjab. Golaknath versus the state of Punjab. Now, this case was a 11 bench case. 11 Supreme Court judges are going to sit in the Golaknath case. 11 judges. And I must tell you, one of my most admired lawyers, someone that I have always admired throughout my legal career and otherwise, Nani Palkiwala. Most of you may not have heard of him, but it is Nani Palkiwala whose first entry happens in the Golaknath case in a very minor capacity. Nani Palkiwala has been a tremendous Supreme Court lawyer, has also been India's ambassador to a lot of foreign organizations, was a remarkable lawyer. All right. Now, let's understand this. So, in the Golaknath versus the state of Punjab case, and this is just 3 years after the 17th Constitutional Amendment of 64. Here, Golaknath challenged the First Amendment, the 17th Amendment, everything, because you could not challenge the laws inside the amendment. So you had to challenge the entire amendment, the entire 9th schedule, and the process through which this was put into the 9th schedule. Right? In this case, the Supreme Court made an absolute role reversal, but again was a very, very minor judgment. Basically, 6 out of the 5 judges ruled in favor of Golaknath and 5 judges ruled against. Just a minor split. Okay. 6 out of the 11 judges ruled in favor of Golaknath. Right? Yes. Yeah. Palkiwala comes later in a greater role in Kesananda Bharti. So Jai Prakash Jha control. I know this. Okay. I don't need you to tell me when was Palkiwala a part of what and what he was not. Just focus on what is being discussed in class. Alright. So in this, the Supreme Court very clearly said, what is this drama about constituent law and ordinary law? Nothing of that sort. Nothing of that sort. If you know what constituent law is, constituent law making power is the powers of the Constituent Assembly. They made the constitution, you did not. So if somebody has constituent law making powers, it's the Constituent Assembly that has law making powers, not you, not me, not the parliament. So if you want constituent law making powers, then you wake up the Constituent Assembly from their graves and then you make them make these laws. Not you, not me. Don't mislead the country by giving these random theoretical discussions, these fancy words of constituent law versus ordinary law and so on and so forth. This is absolutely not acceptable. And this is something we will never tolerate under any circumstances. So therefore, what we are going to do is that we are going to overrule all previous judgments. We are going to overrule all previous judgments. We are going to very clearly say that, very clearly, constituent power lies with the Constituent Assembly and fundamental rights are supreme. Nobody can change them. Nobody, even the parliament, can't. And no law means no law. And constitutional amendment includes, law includes constitutional amendments. Law, as per Article 13, Clause 2, includes constitutional amendments. You cannot change the constitution to violate a fundamental right. They are supreme. Nobody, not even the parliament, has the powers to change that. What a hit judgment. Now Golaknath seemed to be very happy. He said, Areva, now I'm going to get my land back. The Supreme Court is also very, very smart. Supreme Court used an American principle called the Doctrine of Prospective Overruling. The Doctrine of Prospective Ruling. That the judgment is going to be applicable from the future, not from the past. If the court judgments could be applicable from the past, you would violate the integrity of the parliament. So, this judgment is going to be applicable from 67 onwards, from the date of the judgment. So, Golaknath is not going to get the poor man is not going to get his land back. The poor man is not going to get his land back. Absolutely, his land is not going to be given to him at all. वो इतना खुश हुआ होगा कि मेरे को लैंड मिलने वाला है, मेरे को लैंड मिलने वाला है. ओके. बट सुप्रीम कोर्ट बोला नहीं नहीं, ये जजमेंट पुराना नहीं, आगे से किसी के साथ ऐसा नहीं होने देंगे. वो लग रहा बट व्हाट अबाउट माई लैंड, बट व्हाट अबाउट माई लैंड. So that you don't worry, that we've taken. Okay, sorry. So, okay. So this is the Golaknath case of 1967. I think now is an appropriate time for an interval in our movie. So you can take a few minutes. You can take about 5 minutes, organize everything, put everything together, and then we can continue with the rest of the class. You can take a 5-minute break. Vishal, the procedure to insert a law in Schedule 9, that procedure is mentioned. I mean, it's like making any other constitutional law, an amendment. No, Lomashi, it means that the judgment of the Supreme Court will be applicable from the date of the judgment. It does not mean no further law can be added. None of that. You add whatever you want to, but if it violates fundamental rights, we can obviously look into it. Okay, let us continue. Now, the government is going to be extremely angry. There is a Supreme Court judgment which says fundamental rights are supreme, the parliament cannot change any fundamental right, cannot violate any fundamental right, nothing called, no special status given, to what is called a constitutional amendment, and so on and so forth. Okay, nothing of that sort. Zero, no special treatment given to anybody. You carry on as ordinary lawmaking bodies. Now the government is enraged, and now is the entry of one of India's most well-known and also feared Prime Minister's tenure, Srimati Indira Gandhi. Right? Divyansh, you can put any law in the 9th schedule. The parliament has the right to. You cannot enact a state law, but you can put a state law. This is in fact a beautiful example of cooperative federalism being used for the wrong reasons. Okay, all right, good. Now starts the drama. The Indira Gandhi government, through the parliament, enacted the 24th constitutional amendment of 1971. And in this amendment, they basically made changes. They added provisions to Article 13 and to Article 368. They added new provisions to these two articles, and they said, boss, nothing doing, nothing doing. The constitutional amendments are not law as per Article 13, Clause 2. Constitutional amendments are not law as per 13 Clause 2, and the Parliament has the power to make any change. The Parliament has the power to make any change to the Constitution. Any change to the Constitution. Okay? And they also enacted the 29th Constitutional Amendment of 1971. In fact, 1971 is your years with one of the most amount of constitutional amendments. And through the 29th Amendment, they added two more laws to the 9th schedule. and one of them was from the state of Kerala, which is going to now create fireworks in the history of this country. And that, ladies and gentlemen, is the Keswananda Bharati case. The longest written judgment in Indian history, about 800 pages, more than 4 lakh written words, and this is from where the Keswananda Bharati judgment comes, because the Kerala Land Reform Act was added to the 9th schedule, and Keswananda Bharati. It is not Keshwananda, it is Keswananda Bharati versus the state of Kerala, 1973. This had 11 judges, so you are going to now have a 13 bench judgment. The largest ever bench ever created in this history of the Supreme Court. And here also, like a very minor margin, the ratio was 7:6, while 7 judges ruled in favor of the petitioner Keswananda Bharati and 6 judges did not. Okay, 6 judges did not. The Keswananda Bharati judgment was essentially a balancing judgment. It wanted to protect the rights of the people and also at the same time give enough of a consolation or give enough of a leeway to the government. The Keswananda Bharati judgment, comprising of 13 Supreme Court judges, was substantially argued by some of the best lawyers known to the Indian legal fraternity. As I was mentioning, Nani Palkiwala, who was originally playing a very small role in the Golaknath case, played a very, very strong role in the Keswananda Bharati case. And the Keswananda Bharati case becomes extremely interesting in the history of constitutional law, and not just Indian constitutional law, but also international constitutional law. It was a very unique sort of a case for a multiple number of reasons. The first reason why Keswananda Bharati was so unique was because of the anxious political circumstances under which this judgment was to be given. Remember, we are now approaching the years of the emergency. We are now approaching the years of the emergency. If you're approaching the years of the emergency, you know that we are in the era of excessive central governmental control, because that's what emergencies are about. Emergencies are about the central government overpowering the state governments in extraordinary circumstances. 2. While the parliament was the be-all and the end-all of power in the country, it was the Keswananda Bharati case which caused a shift in the democratic power of the country. The parliament no longer was the sole powerful authority of deciding what was right and in the best interest of this country. And what is also very interesting to note here is, out of these 13 judges, 11 judges gave their own separate opinions. And for the first time in Indian legal history, a summary of the judgment had to officially be released by the Supreme Court so that people can understand what the judgment is really about. What is it that people are really going to say? In fact, 2 of the judges refused to sign the summary, saying that this summary is not an accurate representation of what we said. But still, the majority of the judges agreed with the summary. It was fine. Right? And about I think 3 to 4 judges said, no, we're not going to sign it. By the sheer length of this judgment, as I told you, more than 4 lakh words, 800 pages. This judgment is a book itself. And one of the first things that this judgment did is that it was the start of judicial creativity. Alright. So what happened? Basically, Keswananda Bharati was the head of a Hindu religious sect in Kerala. And under Articles 29, you had the right to have religious property, under Article 28 also and 29 also. Now there were land reform acts, and the government had taken the additional land, the extra land, from Keswananda Bharati's religious denomination. From Keswananda Bharati's religious denomination. So he, along with a lot of other petitioners, went to the Supreme Court challenging the 29th Amendment, the 24th Amendment, and so on and so forth. Okay? They challenged the 24th Amendment, they challenged the 29th Amendment very clearly. Now, what did the Supreme Court say? They said, okay, the 24th Constitutional Amendment, okay, which negated the Golaknath case, they overruled. They said this amendment is invalid, we are declaring this amendment as wrong. Okay, we are declaring this amendment to be wrong. Okay, so 1 point given to Keswananda Bharati. Then the Supreme Court also said, any additions that you have made to the 29th Amendment, that's valid. You have the right to add whatever you want to the 9th schedule, no problem at all. And we must also tell you that we are overruling Golaknath, wherein we are saying that you are right, constitutional amendments cannot be law as per Article 13 Clause 2. We completely agree with you. बिल्कुल सही बात. सीना चौड़ा होता जा रहा है गवर्नमेंट का कि वाह, एक तरफ तुमने हमारा काटा है, एक तरफ तुमने हमको सपोर्ट करा है. So they have overruled the 24th Amendment. They have overruled the 24th Amendment. An amendment which basically said that you cannot challenge anything in the Supreme Court. वो वाला part उन्होंने overrule करा है partially. But they also very clearly upheld that, boss, constitutional amendments are not law as per Article 13 Clause 2. And then they used the doctrine of basic structure. They came up with the doctrine of basic structure, and make no mistake, this is not an Indian origin. The doctrine of basic structure actually comes from the German and the Japanese constitutions. Okay. And this was argued by Nani Palkiwala. This doctrine of basic structure was argued by Nani Palkiwala. He said there must be a set of basic obligations, a set of basic principles that nobody in this country should be allowed to touch, and we request the Honorable Supreme Court from now onwards to lay down the ingredients of the doctrine of basic structure, and that is how the doctrine of basic structure came into being. A set of principles, a set of ideas that cannot be violated by anybody. And these set of principles and these set of ideas are going to be given to the country by the Supreme Court. And since then, up until now, the Supreme Court, through various judgments, has mentioned what is basic structure and what is not basic structure. Are we clear with this? Understood? And the Supreme Court also said, whatever has been added to the 9th schedule, up until now, okay, fine, immune from judicial review. But anything added to the 9th schedule from 1973 onwards. From 1973 onwards. And if this violates the doctrine of basic structure, we will strike it down. We will not allow this to happen. Okay? अब तक जो किया सो किया, कोई बात नहीं, रख लो अपनी लैंड, रख लो ये पाप कि तुमने फंडामेंटल राइट वायलेट करे। बट आज के बाद तुम जो भी बेसिक स्ट्रक्चर में, जो भी 9th शेड्यूल में डालोगे, और अगर वो बेसिक स्ट्रक्चर को वायलेट करेगा और वो हम बताएंगे कि क्या बेसिक स्ट्रक्चर है या क्या नहीं, तो आपका वो कानून उठा के हम फाड़ देंगे। From 1973 onwards. Clear? Understood this? Right? तो ये केस है, केशवानंद भारती का ये केस है। ठीक है? Understood this? Yes? This is the Keswananda Bharati judgment. Okay? Absolutely. Very clearly. 24th Constitutional Amendment overruled partially, where it says that okay, the Parliament can change the Parliament can change a law, but the courts can look into it. Upheld the 29th Amendment, said नहीं, आप ऐड करिए, कोई दिक्कत नहीं है। Overruled Golaknath overruled that no boss, constitutional amendments are not law. It's a constituent power. Okay. And then they went on to the creativity tangent. They said, boss, anything added after 1973, as long as it's violating basic structure, I will look into it and I will tear it apart. And I will tell you what basic structure is. Okay? And basic structure is going to be a set of principles. Even in this judgment itself, every judge gave their own list of basic structures. Somebody said parliamentary democracy, somebody said sovereignty, somebody said secularism, and so on and so forth. Okay? So this is the judgment. This is the Keswananda Bharati judgment. ठीक है? Clear? अब ध्यान रखिए, इमरजेंसी लगने वाली है यहाँ पे। अब इमरजेंसी लगने वाली है। Now of course Indira Gandhi ji is very very upset कि ये क्या चल रहा है, ये कैसे करा, ठीक है, ये कैसे करा। So the emergency is now going to be imposed. And this judgment has a certain number of implications with respect to emergency also. ऐसा नहीं है. Has a certain number of implications to the emergency also. The three judges, the three senior most judges who had given a judgment against the government, a part of these 7 judges, ये इसमें से जो 3 लोग थे वो senior judges थे. उसमें से एक को one had to become the Chief Justice of India, not made the Chief Justice of India. In protest, the others also resigned. That why are you violating the senior most principle? And Justice Ray, who was a part of the 6 judges who were giving a judgment in favor of the government, Ray साहब को Chief Justice of India बनाया. Ray साहब has given some very questionable judgments in his tenure also. ठीक है? Now very interestingly, in 1975, Indira Gandhi's election was declared invalid by the Allahabad High Court, because the Allahabad High Court ruled that Indira Gandhi had misused election government machinery for personal election campaigning. The case was Indira Gandhi versus Raj Narayan. The case was Indira Gandhi versus Raj Narayan. Okay? The case was Indira Gandhi versus Raj Narayan. So Raj Narayan was the opponent to Indira Gandhi. He filed a case in the Allahabad High Court because election petitions are filed in the high courts. He went to the court and said Indira Gandhi should have not been declared the winner of the Bareilly constituency because she has misused government machinery and used government machinery for her own election campaigning. Allahabad High Court agreed. Allahabad High Court declared her election as invalid. Indira Gandhi went on appeal to the Supreme Court. Ray Saab was there only. Went to the Supreme Court. Said, ये तो गलत है. Supreme Court ने कहा ठीक है, हमें आपकी बात भी सुननी है लेकिन हमें अपनी इज्जत भी बचानी है. तो एक काम करते हैं, till we decide this case in detail, till we figure out what we should be doing, how about this? You as the Prime Minister of India will continue to be the Prime Minister of India. You have to be present in the Parliament, but you cannot speak and you cannot vote on the floor of the Parliament. गजब बेइज्जती कर दी इंदिरा गांधी, गजब बेइज्जती. Okay. इंदिरा गांधी ने कहा ठीक है, you put a stay on this Allahabad High Court order, you take your time, but you let me be the Prime Minister, because if her election was declared invalid, then she would have not been an MP. That means she would have not been able to be the Prime Minister. And more than anything else, if the very Prime Minister of the country, her election has been declared invalid, what kind of a message are you sending to the country? Especially around the time where regional parties are growing. The Janata Party is gaining strong, and the Janata Party will later become the Bharatiya Janata Party, right? With the support of the Rashtriya Swayamsevak Sangh, which is the RSS. Southern regional parties such as AIDMK and DMK are slowly gaining a lot of political ground. Okay, understood. The second the Supreme Court gave a stay to Indira Gandhi, that midnight itself, Fakhruddin Ali Ahmad was the President of India. She immediately called up the President and said, Chacha, impose national emergency. Impose national emergency. Restrictions are put in place. Article 19 was suspended. The press was not allowed to report on court judgments. And once national emergency was in force, फिर तो सब कुछ भाड़ में गया. So there was a very important correlation between these two events. And during the emergency, जैसे ही हो गया, nothing happens to the parliament. Nothing happens to the parliament during a national emergency. Okay, nothing happens to it. So then, Indira Gandhi government via the parliament passed the 39th constitutional amendment, which said that the election of the president, the vice president, the prime minister and the speaker of the Lok Sabha are immune from judicial review. आप इन लोगों का इलेक्शन इस देश में चैलेंज कर ही नहीं सकते भाई. बात ही खत्म कर दो. बात ही खत्म कर दो. This 39th amendment was again challenged in the Supreme Court. It was again challenged in the Supreme Court. ठीक है? But the Supreme Court struck this amendment down using the same prospective ruling doctrine from the future. ठीक है, आगे से ये अमेंडमेंट नहीं लगेगा. आगे से आप प्रेसिडेंट, वाइस प्रेसिडेंट, स्पीकर और प्राइम मिनिस्टर के इलेक्शन चैलेंज कर सकते हो, ये इम्यूनिटी नहीं है. लेकिन अब तक जो हुआ है, अब तक तो वो इम्यून है. सुप्रीम कोर्ट ऑल्सो प्लेड वेरी सेफ, बट they declared the constitutional amendment 39th one as invalid. From the future, you cannot put immunity to the president, vice president, speaker and Lok Sabha's election, because parliamentary democracy is basic structure. So one of the first applications of basic structure was to strike down the 38th amendment, which wanted to give immunity to prime ministerial elections in 1975. और रे साहब यहाँ तक नहीं रुके. रे साहब wanted to set up a 13 bench judgment, to review the Kesavananda Bharati case. Now this judgment never came out. This bench was dissolved within 2 days for reasons that are not publicly and formally disclosed. So Kesavananda Bharati continued. Kesavananda Bharati continued. Clear on this? Understood? Okay? मामला थोड़ा ठंडा हुआ, चीजें थोड़ी बेहतर हुई. नाउ गवर्नमेंट की आदत खराब नहीं थी. इमरजेंसी का टाइम था. One of the most difficult amendments, the 42nd amendment of 1976 was passed during the emergency. इससे ज़्यादा टेढ़ा amendment नहीं है. This also wanted to give more powers to the parliament, but not through the FR route, but through the DPSP route. वो ये वाली कहानी में काम आएगा. अभी हम यहाँ पहुँचे ही नहीं हैं. In the 44th amendment, after all of this was done, they removed the right to property. कहा यार ये भसूड़ी ही नहीं रखनी मुझे. I don't want to get into this nonsense. Let me just remove the right to property from it being a constitutional, from it being a fundamental right. I want to make it a constitutional right. जब property नहीं रही तो बात ही खत्म हो गई. ठीक है? Clear on this? The 42nd amendment had actually tried to overrule Kesavananda Bharati by saying, again, constitutional amendments can violate fundamental rights. It tried to overrule Kesavananda Bharati by amending Article 368. This was again overruled in the Minerva Mills case. ये मैं आपको बहुत डिटेल में दूसरी स्टोरी के साथ बताऊंगा. ये पहला केस है जिसका प्रॉपर्टी से कोई लेना देना नहीं है, एग्रीकल्चरल लैंड से कोई लेना देना नहीं है. एंड दिस इज द 1980 केस. एंड देन फाइनली वी हैव द IR Coelho case. The IR Coelho case. IR Coelho versus State of Tamil Nadu. Okay, IR Coelho versus State of Tamil Nadu, which is 2007. यहाँ पे ये कहानी खत्म होती है. And the government's last attempt to make it more powerful ended in Minerva Mills. ठीक है? उसमें भी they made it very clear. They overruled the 42nd amendment that no, the parliament cannot make a constitutional amendment that violates fundamental rights to the extent that it violates basic structure. वो हम नहीं कर सकते. And through the IR Coelho case, okay, आपने सुना होगा तमिलनाडु में रिजर्वेशन मोर देन 50% है. वो उसी से रिलेटेड केस था. Because the Tamil Nadu reservation law is actually in the 9th schedule, but reservation is not basic structure. So courts cannot get into whether the reservation under in Tamil Nadu is okay by it being more than 50%, क्योंकि इंदिरा सोनी के गाइडलाइंस है सुप्रीम कोर्ट के कि रिजर्वेशन 50% के ऊपर नहीं हो सकता. But the government put the Tamil Nadu local reservation law in the 9th schedule. Now the courts can't get into it. So IR Coelho said, चलो ठीक है, we can't get into it. Reservation is not basic structure. Tamil Nadu can have a local reservation law exceeding reservation by more than 50%. I think it's about 69%. चलो ठीक है, कोई बात नहीं, carry on. But it said anything added to the 9th schedule, even after 1973, I think it's not visible, right? Anything added to the 9th schedule before or after 1973 everything can be challenged as long as it violates the doctrine of basic structure. Okay. As long as it violates the doctrine of basic structure. ठीक है, मतलब ये सुप्रीम कोर्ट जजमेंट अमेंडमेंट का खेल था. गोलकनाथ में कहा कि नहीं, पार्लियामेंट कैन नॉट मेक एनी चेंज टू एनी फंडामेंटल राइट. 24th अमेंडमेंट, वी कैन मेक एनी चेंज वी वांट टू एनी फंडामेंटल राइट. केशवानंद भारती, बेसिक स्ट्रक्चर, थम जा. ठीक है, कॉन्स्टिट्यूशनल अमेंडमेंट्स आर नॉट लॉ. इवन टुडे constitutional amendments are not law as per Article 13 Clause 2. Agreed. Completely agreed. No problem at all. We came up with the basic structure. 42nd Amendment tried to overrule Kesananda Bharati. Ki nahi, we can make any law violating fundamental rights. Any law. Minerva Mills strikes that down. Ki nahi, boss, you can't make a law violating fundamental rights. It will be applicable to fundamental rights. And then IR Kohlo, anything added or subtracted to the 9th schedule even before 1973, because Kesananda Bharati was after 1973, right? Even before 1973 is okay. बीच में ये emergency का नाटक भी चला. ठीक है? Clear on this? What is very interesting to note, ladies and gentlemen, boys and girls, is that the very first constitutional amendment of India was not by the Parliament of India, was by the Constituent Assembly, which was also the interim parliament. Understood this? That is why you could come up with something called constituent law-making bodies. And the same people who drafted the constitution also in the very first amendment inserted restrictions to fundamental rights. It is a matter of great tragedy that the first amendment to the Constitution of India is actually an amendment for restrictions to fundamental rights, and that also within the first year by the very same people who had drafted the Constitution. Because India's first elections happened in 1952. India's first proper parliament came into existence in 1952. Before 1952, the Constituent Assembly became the interim parliament. And they continued as the interim parliament until we had fresh elections in 1952. India's first ever elections were in 1952. Very interesting to note that the first amendments to the constitution of the country, the background on which this great document called the Constitution of India exists, rests upon, stands upon, is on basically the issues of a violation of fundamental rights. Okay? Understood this? So this is the first story. And it's not, and you must understand, Kesananda Bharati is also the application of constitutional morality. Morality as per the values of the Constitution. It upholds the values of constitutional morality that the makers of the Constitution originally envisioned, that the Parliament abides by the certain principles of the Constitution. These basic features are nothing but features of constitutional morality. That is why the very first question in the mains exam this year says, explain constitutional morality on the basis of essential facets of the Constitution. Essential facets means the same thing as basic structure. They were simply just trying to trick you. Okay. It's not that the Kesananda Bharati judgment is the best judgment ever written. No, that's also not the case. By the sheer length of the judgment, one never really knows what is it that the judgment is really trying to say. By the sheer length of the judgment, what is it that the judgment is really trying to say? What is it that the judgment is really trying to put across as a view, as a point? Because no one still knows clearly what basic structure is. It is an interpretation, it is an idea. And because it is an idea, and it doesn't exist in the constitution. Nothing in the constitution reads basic structure. There is no line that says basic structure. So the parliament cannot override basic structure. You can't make a constitutional amendment saying there shall be no basic structure, because there is no basic structure in the constitution in the first place. So the only way the constitution can override this, or the only way you can override Kesananda Bharti is A, you have a 13 bench and higher judgment, which is very unlikely in the current times. Or two, the parliament tries to do this by, by extra constitutional means. कि वो 368 में कुछ जैसे 2-4 उंगली कर दी इधर उधर करके, जैसे 42nd में किया था, 24th में किया था. Both of which can be struck down by the Supreme Court. No doubt, the basic structure doctrine has saved the political democracy, has saved democratic principles of India. No doubt, I completely agree with you. It has firmly established judicial review and the advent of judicial supremacy. No doubt. But this judgment also very clearly says that the Supreme Court is the unmatched, unquestionable authority when it comes to the parliament, when it comes to the constitution. Unmatched authority when it comes to the constitution. And this judgment was so exhaustive, it has also been used by the Supreme Courts of our neighboring countries, to protect them from totalitarian regimes, to protect them from, parliamentary overreach. So there are some good things and there are some bad things. But let's understand, what Kesananda Bharti basically did was reviewed existing legislations. The 24th Amendment, the 29th Amendment, it reviewed a prior judgment, it reviewed the earlier amendments. It did what it has the powers to do so. It firmly established judicial review, no doubt. Absolutely no doubt, unquestionably no doubt. It was a rescue operation. Agar ye nahi karte, then the parliament could have easily removed all fundamental rights and you would sit with this one right saying, हाँ पकड़ ले बेटा, अब क्या करेगा? बस ये पकड़ के बैठ जा. See, if you have to choose between the Supreme Court and the Parliament as the savior of democracy, given the quality of parliamentarians, we would end up choosing the Supreme Court. This is not healthy, but we are compelled to make that choice. And that is the analysis of the Kesananda Bharti doctrine. Okay? Understood this? And remember, our first lecture on constitutionalism, the essence of constitutionalism is controlling the powers of the government. So if basic structure does not exist, constitutionalism will not exist. So it is only in the interest of upholding constitutionalism and the values of the constitution that you require the doctrine of basic structure. But that does not mean that the Supreme Court abuses this power, because it has. It has used this basic structure doctrine and struck down the 99th constitutional amendment, which created the National Judicial Appointments Commission, an independent body which was supposed to transform the way Supreme Court and High Court judges are appointed and removed. ठीक है? Understood this? खेल यही है. All right? खेल यही है. इस देश का बहुत कुछ यहीं से आया है. बहुत कुछ. It is because of land reform movements in Rajasthan that the Mazdoor Kisan Shakti Sangh years later revolutionizes this country by articulating the right to information. ठीक है? It is because of these developments that you see around Kesananda Bharti, 42nd, 44th Amendment, that you today see the land acquisition resettlement law. इस देश का सबसे बड़ा legal principle starts with land, and today also land is the most contested legal प्रिंसिपल इन द वर्ल्ड, स्पेशली इन इंडिया। हमारा लैंड रिफॉर्म रीसेटलमेंट लॉ पिछले 10 साल से पेंडिंग है। अगर ये नहीं होता तो ये नहीं होता। अब आप सोच रहे होंगे सर ये सब तो ठीक है, केशवानंदा भारती को अपनी लैंड मिली? नहीं मिली। डॉक्ट्रिन ऑफ प्रोस्पेक्टिव ओवर रूलिंग। लैंड किसी को नहीं मिली, सबको ज्ञान मिला है। ठीक है, अंडरस्टूड दिस? ओके, ऑल राइट। यस आकाश, wherever it is used rarely. Yes अखिल, ठीक है, समझ में आया? तो हमारी पिक्चर की एक कहानी तो आज खत्म हो गई है ना, आराम से खत्म हो गई, समझ में आ गया, बढ़िया खत्म हो गई। ठीक है, ऑल राइट, क्लियर? मजा आ गया ना? This is one of my favorite things to teach. थैंक यू, थैंक यू। अभी तो वी हैव टू डिस्कस मिनर्वा मिल्स, अभी सब विल डिस्कस दिस टुमारो। ये जो कहानी है 42nd 44th, देयर इज गोइंग टू बी द 25th अमेंडमेंट, ये यहाँ पे 25th अमेंडमेंट ऐड होगा। वी गोइंग टू डिस्कस 42nd 44th मिनर्वा, वी गोइंग टू ऐड 2 more cases here and then we'll have the second layer to the story. पहली लेयर समझ में आनी चाहिए, दूसरी लेयर विल कम टू दिस। ओके, थैंक यू। चलिए, revise this today. If you open your Google Drive, in the mains updated folder, theme number 1, you will find the notes of all of this. You can read it, be prepared, and we'll discuss the evolution of directive principles and fundamental rights tomorrow. ठीक है? Yes. All right. Thank you. Thank you. Yes, you will find the notes for this in the Google Drive. I'll show this to you if you want to, in case you are not sure. मैं दिखा देता हूँ आपको, ये नोट्स आपको बिल्कुल मैंने बना के ऑलरेडी दे रखे हैं। This is your Google Drive. Go to mains notes, updated notes, go to mains syllabus 1. ठीक है, थैंक यू। ठीक है, कुछ नहीं करना है आपको। सी दिस इज अ पार्ट ऑफ द लास्ट लाइन ऑफ द फर्स्ट पॉइंट, बेसिक स्ट्रक्चर। ठीक है, इस पे क्वेश्चंस हम कल डिस्कस करेंगे। आप चाहो तो ये क्वेश्चंस देख सकते हो, आप देखो कितने आराम से सॉल्व हो जाएंगे। 2019 में पूछा था, देन देयर वाज आई थिंक अ क्वेश्चन इन द अर्लियर ईयर्स, यहाँ पे था क्वेश्चन 2013 पे। आप सीख जाओ, कभी भी हिस्ट्री पे कुछ पूछा नहीं, विल कवर द क्वेश्चंस टुमारो। एंड द फर्स्ट टॉपिक हियर इज 368 एंड बेसिक स्ट्रक्चर। मैंने आपको सारे पॉइंट्स, इवॉल्व कैसे हुआ, ये डायग्राम पूरा बना के, ठीक है, बेसिक क्या कॉन्टेक्स्ट है, क्या इंसाइट्स हैं, की माइलस्टोन्स की मतलब क्या बेसिक जजमेंट्स रहे हैं, उसके बाद केशवानंदा भारती का डिटेल में क्या जजमेंट दिया, केशवानंदा भारती के बाद मिनर्वा मिल्स में क्या कहा गया, 368 का करंट स्टेटस क्या है, केशवानंदा भारती और इमरजेंसी से क्या रिलेशनशिप है, बेसिक स्ट्रक्चर का क्रिटिकल रिव्यू, पॉजिटिव नेगेटिव पॉइंट्स, कंक्लूजन हमें एग्जाम में लिखना हो तो क्या लिखेंगे, कैसे लिख सकते हैं, क्या इसको ओवररूल किया जा सकता है या नहीं, और क्या जब हमने ये ऐसा किया है क्या ये सही किया है या नहीं। इसके बाहर एग्जाम में कुछ नहीं आएगा, ये मेरी गारंटी है। ठीक है, चलिए, thank you so much. Thank you, all of you. Take care too. Right? I'll see you guys tomorrow in the morning at 8 o'clock. Have a good Sunday, and this takes care of most of it. ठीक है? All right. See you. Bye.